Tēnā koutou, tēnā koutou, tēnā koutou katoa. No tamaki makouta ahau, ko te rāna no aira na whenua o oku te puna. Ko Mangakiki e Maunga, ko ia mahia e mahara taku e Ngaro, ko Waitemata te Moana, ki te Ngā Kaumanawa, ko Rachel Smith tōku ingoa, no reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. It's lovely to be here and to see old faces. I can see old people, not old from relationship length, not in age. It's nice to see connections of people that I've worked with in the past at hospital and the various roles that I've had. So I feel like I've been old because I've been in the sector for about 25 years. So just it's wonderful to be here. And I feel I'm being a bit rude because I'm looking at the camera so I can see everyone online, but then I have my back towards everybody in the room. And so excuse me if we're going back and forth, and we're just going to share the slides. We've had some real challenges with my technology. I've got a laptop at the moment that the camera doesn't work. So straight after this presentation, I'm getting a new laptop. And then my phone has been run over by a car. And so that's my problem with the duo. So aroha mai for the challenges today, and luckily Jane has got everything which she's just about to bring up very shortly on the screen.
So you should be able, Rachel, to just page down, I think. You want to start with this one?
Sure. I mean, before I start, I just wanted to acknowledge that everything that I'm sharing today, we know knowledge is relational. And so coming to know what I've got to share today is actually based on a whole range of people's knowledge, particularly the work that I've done with Professor Denise Wilson and Professor Julia Tolmie over the years, people such as Jane. And so everything that I'm sharing, it's not my knowledge, my ways of knowing, it's built on, most importantly, the people's lives that we had the privilege to review. So it's built on the knowledge that we have learned from reviewing family violence, homicides, so families and whānau's experiences of violence, resistance to violence and transformation. This knowledge is not innocent, it's not equitable, and so having been part of that work requires responsibility and accountability to commit to making change. And so that's what's really driven the focus of what I'm going to be sharing with you today. Let me just get this. I think we could go just to do that little tiny arrow.
Okay.
Yeah, we'll just have to. As I said, I've spent 7 years doing family violence death reviews, and some of those death reviews involve primary victims who had killed their abusive partners. And what was really evident from doing those reviews is the experiences of oppression and violence that these wahine had experienced before the death event, but also after the death event, and the process of engagement with the criminal justice system. And so while these might be small numbers, when we actually look at the outcomes of these women in the court processes, they have some of the largest justice gaps that we have in our justice system at the moment. And so their experiences of brutality and violence is really not understood within our court process. And so we need to be thinking about how do we make change. So despite these women often being under attack from an abusive partner trying to defend themselves or their children, their experiences and responses to that lethal violence is not understood as self-defence. And so what we saw in the death reviews and what we continue to see is, most of these women, they either plead guilty early to a manslaughter charge, or they're very unlikely to be acquitted of self-defence. And we have very, very few acquittals, and the few acquittals that we have generally been because other third parties actually witnessed the death event. So there was other accounts that gave meaning to their experiences. And when we look at who's grossly overrepresented in this group of defendants, it's actually wahine Māori. And so why is this happening? So a lot of the expert testimony in court has actually been based on Western understandings of intimate partner violence, and it's been based on a lot of Eurocentric psychology and psychiatry. And so when we look at these women's experiences, they're actually at the intersection of socio-political injustice as well as knowledge-related injustice when they enter the criminal court system. So what I'm going to be focusing on today is looking at those theories that inform intimate partner violence expert testimony, because theories really, really matter, because the theories we draw upon to make sense of people's lived experiences, they make it very visible whose lives we centre and whose lives matter. And so when we draw upon Eurocentric theories, and we keep those as the mainstay, as we have always done in a lot of the mainstream intimate partner violence work, then we are actually supporting oppression of Indigenous and racialised women's experiences of violence. And so being a Pākehā settler in Aotearoa and being accountable to upholding Te Treaty, my work needs to be focused on dismantling these structures of white dominance and really starting to look at the roots to these knowledge systems, because otherwise we're in danger of going, oh, battered woman syndrome, that's the old way of thinking about intimate partner violence. Let's just swap that out for coercive control, and not addressing the epistemic knowledge roots of those ways of thinking about violence, and actually how there's a lot of similarities rather than differences. And so we know when we look at settler colonialism, how this is an ongoing pattern of violence against Indigenous peoples, and is why we see the overrepresentation of wahine Māori as defendants in cases where they've killed their abusive partners. And so it's the imposition of ongoing colonial patriarchy, institutional intergenerational trauma. And I use that term purposefully because we often talk about intergenerational trauma, but when we look at what's been happening in Aotearoa, such as the Royal Commission, we see that a lot of these histories of violence and abuse actually occurred within institutions. And so if we put institutional in front of intergenerational trauma, then we realise the change project needs to be at the institutional level. It's not something for communities and whānau and families to be responsible for addressing. So we know that we are in a country that's founded on colonial violence, on systemic inequities, and paying attention to this and making this visible in the ways that we think about intimate partner violence is absolutely critical at this juncture, when we have a current government which is focusing on division and focusing on embedding these racist narratives that are evident when we look at our media stories. People might not be aware of the term epistemic oppression, and I draw upon the work, and this is a picture of Kirsty Dotson, and she is a Black feminist philosopher. A lot of people might be aware of the term epistemic injustice, which actually comes from a white feminist called Miranda Fricker. But what Kirsty Dotson's talking about is she's saying that when we look at knowledge-related forms of oppression, we really need to look at the whole entire system. And so she's drawing attention to how systems are set up by design, not by default. So when we look at settler colonialism, it creates a whole system of knowledge production, of whose knowledge is valued, of what knowledges get precedence on purpose. So this isn't by accident. And so if we're trying to make changes, then we need to look at the whole entire system. And so when we're looking within the criminal court process, we have the privileging of Eurocentric psychologists and psychiatrists that get to talk about intimate partner violence testimony. And this has been clearly demonstrated by some work by Nash and Davisco over in Australia. They looked from 2010 to 2020 at all the cases where victim survivors have killed their abusive partners. And most of the people giving expert testimony are psychologists and psychiatrists, and the sort of expert testimony they give is based on psychopathology. So it's focusing on the victim survivor's mind, on their psyche, and problematizing their mind and their body reactions. Sometimes, we call that trauma-informed. And so this is what's currently dominant. And we also then need to, if we're looking at the system, we need to look at the Western court system, and why is it that Eurocentric psychologists and psychiatrists fit so well into a Western liberal system of law. And if we think about the work of people such as Moana Jackson, he talks about how if we to understand colonialism in Aotearoa, then we actually need to go back and look at what happened to the Indigenous peoples of the America. And we have to go look back at the whakapapa of violence. So I think it's really important to understand how is it that Eurocentric psychology and psychiatry is centred and still takes prominence within our criminal justice systems. And if we look at the history of Eurocentric psychology and psychiatry, it's absolutely connected to coloniality, systemic racism, sexism, and epistemic violence. You might think, well, what on earth are those terms? So epistemic violence is the knowledge-related violence. So it's when you impose a way of making sense of people's experiences that actually does not match their experiences. And this is what we're seeing with intimate partner violence when we use Western ways of understanding intimate partner violence that exclude the social realities that these women are living, which we'll go into a little bit more. And so I don't know if people are aware of Brosfield's work, but when we look back, there's been 4 huge genocides and epismicides in the 15th and 16th century. So if you think about what was happening in the 15th century, we had the doctrine of discovery, which were the papal bills that gave the monarchies of Europe and Britain the authority to go out and take already discovered lands and kill Indigenous peoples. And so this started to happen when we looked at what happened in the Americas. And so when we look at the first genocide, this was actually from the Catholic monarchs, and it was against the Muslims and Jews that were in the Muslim area of the Iberian Peninsula. And then the second genocide was the Indigenous peoples of Aotearoa by the Catholic monarchs of Spain. And this was in the conquest of the Americas. So this was where we see that the model of power and knowledge that still has a huge impact in the modern world was developed around all the hierarchies around racism and gender. The third genocide was against the African peoples and their enslavement in the Americas by the monarchies of Europe and Britain. And the fourth genocide, which is often not spoken about, was actually against Indo-European women. They were accused of being witches, and actually these women supported their communities as wise women, as healers. They were also the tenders to communal lands and the cultivation of communal land. So this is when we look at genocides and why we call them epismicides, because the killing of people is linked to the killing of knowledge and was also linked to the killing of spirituality. And so we have this cataclysmic destruction that meant that we could give rise to what happened in the European Enlightenment. And so what happened there is that we saw, the rise of the scientific paradigm, the medical science, and liberalism. And so we're talking about centering white Christian Western European men's knowledge. And this, in the European Enlightenment, as we saw in the 19th, 18th and 19th century, was the rise of the psych disciplines, so psychology and psychiatry, that tried to centre themselves in this scientific paradigm. So we saw the shift of power from religion to science. And so what we saw there was the oppression of Indigenous peoples, Black people and women, now occurring through pathologisation and criminalisation and suffering. And this is really, really important because this is what's been happening for a long, long time. And it's only in 2021 and 2023 that the American Psychological Association has actually apologised to people of colour, first in 2021, for their involvement and their sustaining of systemic racism. And so if you go onto their website, they've got a chronology where they're actually looking at how many of their presidents were involved with the Ku Klux Klan, their involvement in eugenics, the ways that, psychological thinking has supported embedding systemic racism across society. And, when we look at the universities, what's been taught in the universities. And it wasn't to 2023 that they've actually apologised to Indigenous peoples in the Americas for the impact that psychology has had on Indigenous peoples. And lots of people talk about that as psycho-colonisation. And so we're just really starting to look at that these aren't neutral bodies of knowledge, that a lot of Eurocentric psychology and psychiatry is actually based on and supports harmful ways of thinking about people's lived experiences. So why is this important? When we look at a lot of the intimate partner violence testimony, there has been two main approaches, psychopathology and psychological approaches. And when I'm asked to do expert testimony, every time I'm asked, people say, can you come talk about battered woman syndrome? So you'll see, while this is like 1979, and we know that Leonie Walker's work has been discredited, her work's actually based on the work of abused dogs, and Michael Seligman, who did the work around abused dogs, actually says that her work doesn't represent the work that he did. And so we know that battered woman syndrome is really outdated, that it's based on pathology. It talks about the reasons women can't leave their abusive partners as they develop this learned helplessness after experiencing cycles of abuse. So while this was discredited when it came about, it is still deeply embedded in the ways that we make sense of women's experiences and responses to violence when they're in the criminal court process. And one of the ways that it is kept alive is actually in the Western trauma-informed discourses. And whilst Western trauma-informed discourse aim to move away from the biomedical model to understand what happened to people, what happened to you is trauma, so what becomes wrong with you is trauma. And so the Western trauma-informed discourse hasn't actually moved away from that biomedical model. And if you look at a lot of Indigenous critique, very critical of the way Western trauma-informed discourses have embedded themselves in the family violence and sexual violence sectors, particularly in America. There's a lot of critique about how now trauma has made these therapeutic bureaucracies. And so now women, survivors of intimate partner violence, have to prove that they've actually recovered from trauma. And that's what a lot of the program funding is funded towards trauma-informed. When we know that the problem is not women's minds and their bodies, the problem is the responses from services and the forms of oppression that they're experiencing in their lives and their communities. So then we moved to trying to do sociological approaches. And there's been a lot of work looking at social context evidence, which was trying to move away from understanding that women are battered and that they're defenceless and they are passive, to making visible that there weren't many refuges to go to, that the police response wasn't very good. And a lot of this work was happening in Australia and the States, and trying to bring in this other knowledge into the criminal justice system. One of the big problems there was actually it was still being brought in by psychologists and psychiatrists. And so what you had them doing battered woman syndrome and then trying to tack on some of the social context evidence on the end, which was not very effective. And people are probably aware of Evan Stark's work. So Evan Stark made a huge shift of saying that the domestic violence movement in the US had lost their way. They've been so focused on physical violence that really they had misunderstood intimate partner violence as a crime against someone's ability to be self-determining. So it's actually a liberty crime, a gendered liberty crime. And this is quite a transformational paradigm. And so what a lot of legal academics and feminists wanted to do was start to bring coercive control evidence into the court. And so as part of expert testimony, present coercive control rather than battered woman syndrome. And part of coercive control was also trying to bring other people into the courtroom. So starting to bring social scientists, sociologists and social workers to start giving expert testimony. One of the problems with coercive control is, and Evan Stark actually acknowledged this, and I know he's passed, so I just want to, acknowledge the huge change that he did contribute. was that it only focuses on gender inequity. And so while it's focusing on coercion tactics and controlling tactics and how these work together, it didn't actually address other forms of structural violence and structural inequity. And so, as I was saying before, if we just swap out battered woman syndrome, say we want to be anti-pathologizing, and so we're going to adopt a sociological approach, we're still not dealing with those roots, which are still connected to centering whiteness and Eurocentric thinking. And so this is one of the big critiques, that coercive control is still considered white-centred feminism, which I'll come on to talk about a little bit more. And one of the biggest challenges as well is, as people have probably been seeing in Australia, and it's probably something which we're going to look at in Aotearoa, is the push now to criminalise coercive control. And so what's happened, particularly over in the UK, where they criminalise coercive control, is to make it a criminal offence, and so it didn't replicate other criminal offences, they made it to focus on non-physical forms of violence as a pattern of harm. And so this has now meant that often when people are talking about coercive control, they are using it as a shorthand for psychological emotional abuse, which is really problematic because this actually misrepresents even Stark's work. His work was not on categorising forms of abuse, it was actually looking at liberty violations. So it wasn't about this is non-physical abuse, this is physical violence, and hence his term coercive control. But what it also does is it actually pushes, if we start to conflate coercive control with forms of violence that are psychological and emotional, and it's not to say that those aren't important forms of violence to focus on. What we're doing is we're pushing to the periphery a lot of women who experience severe sexualised violence and physical violence from their partners and their partners' associates. And when we look at the defendants who killed their abusive partners, I use the term brutality because if you have a look at what they have survived, violence often doesn't actually match their lived experiences. We're talking about severe brutalizations and transgressions of people's personhood for, continued long periods of time. And often some of those relationships were never consented to in the first place. So despite someone looking like they've been with a partner for 20 years, when you go back to actually how that relationship formed, that was not a consensual relationship formation. And so we really need to start to be thinking about what are the forms of violence that we're talking about here. I hope everyone's following along. I was meant to be reading off my notes, but as I often do, then I start ad-libbing. So it's a bit of a strange setup here for me, looking at the screen and not having my screen in front of me, but that's all right. And so we need to be really, really careful about criminalising coercive control and thinking about all the different forms of violence that we may be starting to embed if we criminalise coercive control in Aotearoa. And so here's some quotes just to take a moment to read. And you'll see Dr. Marlene Longbottom. So Dr. Marlene Longbottom has written a lot about systemic entrapment over in Australia, and about how systems, carceral systems of containment for Indigenous women and children. And we can see what's happening over in Australia where, they've got lowering the criminal age to 10 for children. And we think about what happened in Aotearoa, some of the legislation that we had that gave rise to so many young people being taken to state care. We had the criminal age at 7. And so they, when you look at most of the Aboriginal academics and women's organisations have been very vocal about saying do not criminalise coercive control because Aboriginal women are already underprotected and over-criminalised in Australia, and this is going to exacerbate this. And so we're going to start seeing Aboriginal women being misidentified as predominant aggressors, and they will probably more likely be the people who are going to be prosecuted as coercive control. What's happened over in Australia is that some of the states have actually started to criminalise coercive control, and that has been done based on different understandings. So Scotland criminalised coercive control. Their understanding of coercive control is more aligned with Even Stark's, whereas I see what's happened over in England is more aligned with a psychological understanding of coercive control. So we need to really be thinking about the harms in Aotearoa, particularly when we see the hyper-incarceration of wahine Māori. We've got one of the highest rates of incarcerating Indigenous women in the world, and the current government policies, which are supporting, 3 strikes, that this, while a lot of advocates and victim survivors, it's really important to validate and acknowledge people's experiences of violence, we have to think about what are the harms that can be caused from criminalising coercive control. And there's a lot of work also talking about refugee and migrant women's experiences, and that's this article saying that they're going to be collateral damage. So if we're thinking about upholding Te Treaty, then we need to be very, very careful about criminalising coercive control. So Johnson talks about coercive control as an example of white-centred feminism. So this moves on from the white feminist thinking of the 70s and 80s. White-centred feminists do say that they understand racial difference, and often this is demonstrated by understanding intersectionality. And so what I've got here, and I know that you won't be able to see the family violence and sexual violence in New Zealand image that well, but you can go to Te Rere Kura Action Plan and download that, is the misunderstanding of intersectionality. So when Kimberly Crenshaw developed this theory, and also from a lot of the community activists at the time, what they were trying to do is draw attention to how the Western feminist movement invisibilised Black women's experiences, and how the civil rights movement invisibilised Black women's experiences. And so they were talking about the intersections of racism, of sexism, of these structures of oppression that needed to be addressed. And what we've seen around a lot of use and misuse of intersectionality theory is focusing on people's individual identities. And that's what we've got here in Te Rere Kura. And so we're focusing on different groups' experiences of violence without attention to the oppressive structures that give rise to those overrepresentation. That makes sense to people? And so this is what we see all the time, is that really radical thinking gets depoliticised and turned into supporting the status quo. And so when we look here in this action plan, it's not talking about addressing the systemic issues that result in wahine Māori experiencing severe intimate partner violence and being over-criminalised and incarcerated in our country. And that's what we need to be focusing on, rather than just developing service responses. And so this is what we've got to be really, really careful of, and it's what we're also seeing happening with coercive control, by redefining coercive control to focus on non-physical forms of violence. That's actually centering and embedding white women's experiences of intimate partner violence. So while people might think, well, that's not my intention, that when we're doing anti-racism work, we don't look at the person's intention, we need to look at the consequences. The consequences are borne by the people who are experiencing the burden of oppression in our society. So we need to be looking at these misuses and actually addressing them. So the work which Denise, Julie and I have been trying to do is shift these discourses in the criminal court. So how do we get away from using battered woman syndrome and start to move to using conceptual frameworks that actually can encompass all victim survivors' experiences and responses to violence. And so it's placing coercive control within a framework of social and systemic entrapment. And I know people would have been hearing me talk about this for many, many years. And why it's important is those old ways of thinking are so deeply embedded in our system, they're actually really hard to remove. And I know in some of the family violence intervention coordinators have said to me at different conferences over the years that they still have battered woman syndrome as part of the training, or that's a way of making sense of people's experiences. So we know that these just don't go away. They're actually embedded in our psyche, and they're also embedded in our psyche because we live in a neoliberal country. And neoliberalism supports people blaming victims, it supports individualising people's experiences and not looking at the social context. And so most of those forms of making sense of intimate partner violence, they either focus on the victim, like battered woman syndrome, trauma-informed, we're focusing on her either bodily responses, her brain responses. When we move to coercive control, we're starting to look at the abusive partner, which is really important, and their coercive tactics, but we're not looking at these people within the social context that they live. And so that's what we're trying to do around social and systemic entrapment. We're saying that you need to place intersectionality in a settler state. We need to place it within the infrastructure of colonialism, ongoing settler colonial violence. Without that, then we're likely to be causing harm. And so what makes this really, really important is we know that when women who are facing lethal violence make decisions to act, they are looking at everything their partner has ever done to them and all the threats they've ever made to them. And they're also thinking about what level of system responsiveness they have access to. So if I run out onto the street, will my neighbours ring the police? Will anybody do anything? And so these are all the things that they're thinking about when they take action to defend themselves and their children. So if we do not look at dimension 1 and 2, then we actually erase that system responsiveness. And if we erase that system responsiveness, we can't actually make sense of their responses. And when we're in a criminal context, we're actually trying to say, was their use of violence reasonable? And one of the problems is when you bring the trauma discourse in, then you start to be saying that people were responding because of their trauma experiences, then it doesn't become reasonable. And so what we're trying to do here is say, if you make visible people's experiences to violence, then their responses start to be seen as reasonable. And why this matters is, when we're talking about putting people in prison for manslaughter or murder, you're talking about really long prison sentence, and that's experienced intergenerationally. And so we know we were involved in a case, Rudell, where I gave expert testimony, but it had to be counterintuitive, and there was still the other expert testimony by a psychologist. So what we want to be getting to is being able to apply social and systemic entrapment analyses to the defendant's actual lived experiences rather than as counterintuitive evidence. Because it really makes sense if you're able to tell the court, last time she rang police, it took 58 minutes for the police to get there. Then you understand someone's not in flight or freeze mode. They're actually thinking, last time I rang, the police took 58 minutes to get here. Someone's going to be seriously harmed before that. Or last time I rang, the police, I actually experienced a really racist response, so I'm never going to ring them again. Or that's actually going to be more dangerous. And so these are all the things, if we don't make that visible, then we are completely misrepresenting people's experiences of violence. So one of the things that we've actually done is we used to have coercive control up as the first part of social and systemic entrapment. And then we had the other two layers, so looking at system responsiveness and then looking at how forms of oppression impact people's experiences and availability of services. And what we found is a lot of people saying, yeah, I'm using a social and systemic entrapment lens, and they were just really talking about coercive control. And those other, because this is not coercive control plus, it's actually seeing that all these different forms of violence, the violence from systems, the violence from systemic inequities, and their partners' violence are mutually formative. And so they're completely interconnected. And that's why I say beware of the blur effect. And so what happened is the other two dimensions sort of just got blurred out. So people were just focusing on coercive control. So that's why we've inverted it and said actually, people, their experiences are shaped by those larger structures out in society of, if I bring up this refuge, are they going to actually help me? What have their experiences been of a rangatamariki? We've seen around the Royal Commission, and we've seen over the last, 10 years, or the Waitangi Tribunal kaupapa inquiries around a rangatamariki. It is a real reality that a lot of Wahine Māori's children will be taken off them. And so that is going to inform your help seeking and who you see as safe. And this is why it's absolutely critical that we make those other levels of entrapment visible. I'm racing through this a little bit just to get to this last slide. And so we do have this recent article that we've published. And really what we're trying to do is shift from this I go to we go, and recognising that when you present in court, it has to be drawn upon multiple people's experiences and knowledge. And so we're wanting to develop, we need to actually be training people up on social and systemic entrapment, because we've got a shortage of people that could actually give this expert testimony. Even if it's accepted in court, then you've got a workforce issue. And part of that workforce issue is that you need collectives, and so you need a legal, academic or practitioner. And this is some of the problem with trauma-informed discourse. That might be really helpful in a medical context or in a community context, but when you take that into a legal context, which is about morality, it can cause a lot of harm and unintentional harm. So you need to have people who actually understand how the law operates and how things are landing in that legal system. You also need to have people who know about how the family violence response system actually functions, who've actually worked in that space. Because what we've seen is a lot of psychologists and psychiatrists, and there's been some great work over in Australia, and I'll add that to the reference list as well, who they've actually interviewed psychologists and psychiatrists, and they said, we know the issues aren't around these women's minds, but that's what our expertise is in. They're not experts in how the family violence system functions. And so we need to start to be having, as part of the collective, people who actually work within the system, who actually know in that local area how responsive services actually are or are not. We need to be aware of the limits of our knowledge. And so there was a case over in Australia where a psychiatrist gave evidence, and she said that the family violence system worked perfectly for female victims, which is actually not true at all. And so it's really, really harmful when we have people talking into spaces where they actually don't have experience. So what we're saying is, whilst one person might present evidence in court, how do you draw upon collective knowledge? Particularly if you're working with Wahine Māori, how will you actually make sure that you've got academic scholars and practitioners who have that knowledge to support you to do that work? So reflexivity is about recognising the limits of our knowledge and recognising that we can't keep using harmful ways of thinking because they work in individual cases, and that often happens around the trauma-informed discourse. People say, oh, but it works, I got a compassionate outcome. But a compassionate outcome for who? Often that's probably going to be a middle-class white woman, and it's not going to be Wahine Māori. And so we need to be thinking about how we're trying to shift this collectively, not individual case by case, because otherwise we can unintentionally be embedding ways of thinking that are actually going to be harmful for the majority of the defendants who are up before the courts. And that's just where I was going to end it. At the end of my presentation, and sort of race through that a little bit, so I was probably not quite as articulate as I normally am with all the different challenges. But hopefully people might have a look at that article and really take a look at the theories that you're using in your workplaces and look at what some of the unintended harms actually are, and think about how you can make some changes there, because that's what accountability actually looks like. And we need to be making sure that our ways of thinking actually align to equitable and just practice, and what are some of the shifts we need in that space.